The government is not confined in its proof to showing the particular acts alleged in the 2 counts of the indictment as evidencing the evidence of the continuation or conspiracy. It may proceed and show the performance of all other acts and things done or committed by the defendant, tending to show their existence and purpose, since, as I have said, it is from these things that the existence of the combination or conspiracy may be inferred. In other words, having shown some one or more of the specific acts charged, it may proceed and show everything done by the defendants, or any of them, of a character tending to establish the existence of the conspiracy or combination, their participation therein, and the purpose to be accomplished. Bearing these considerations in mind, you will be readily enabled, should you find that a combination and conspiracy existed, to determine whether it had for its purpose the intent to violate this statute as I have defined it to you. This is so because the law is that the intent or purpose with which a thing is done is to be determined from the nature of the acts committed and the facts and circumstances surrounding the party charged at the time he did them, and drawing therefrom such inferences and deductions as men of reason and judgment, familiar with the practical things of life, would ordinarily draw or gather from such facts and circumstances. It is not at all necessary that there shall appear any open, direct, or explicit declaration of the interest with which a given act is done. As I have before indicated, men engaged in an unlawful enterprise do not usually proclaim in any open way their purpose in what they do, and so we are permitted to resort to the circumstances and say what they import. If this were not so, it would be rare that the real purpose or intent of a given act or series of acts could be ascertained in establishing crime, since, as has been truly said, there are no windows to the human mind through which we may observe its inner workings. Hence, we are relegated to the observation of its outer manifestations, and the most significant of these are the acts it dictates to carry out its purpose. They are more reliable for such purpose as a rule than express declarations, since words may be used as a mask for what is really in the mind. When the intent or purpose is thus ascertained, it satisfies the law, and you are at liberty to regard it as established by the evidence. The burden of proof in this case, as in all other criminal prosecutions, is upon the government. The law presumes the innocence of a defendant, and that presumption abides with him throughout the trial and until his guilt is satisfactorily established by the evidence. This is a requirement of the law which is intended for the protection of the innocent and to guard, so far as human foresight may, against the conviction of those unjustly accused of crime. It is a substantial right and should not be ignored by the jury. Before a conviction may be had, it is incumbent upon the government to prove each element of the offense essential to the guilt of a defendant by evidence which overcomes this presumption of innocence and satisfies the minds of the jury beyond what is termed in the law a reasonable doubt. And that means by evidence which satisfies their minds to a moral certainty and which accords with their reason and judgment to an extent which would induce them to act in the most important affairs of life. As it has been well expressed by an eminent jurist, a reasonable doubt arises when the jury, after a fair and impartial consideration of all the evidence in the case, are unable to say that they feel an abiding conviction to a moral certainty of the truth of the charge, a certainty which satisfies the reason and directs the understanding of those who are bound to act conscientiously upon it. If, therefore, after a full consideration of the evidence presented, the jury are conscientiously able to say that they entertain such a doubt as to the guilt of the defendants on trial, or any one or more of them, they must resolve that doubt in favor of such defendants by an acquittal. And if you entertain such doubt as to all the defendants, then you should acquit them all. This applies to the jury as a whole and to each individual member. But you will not understand from this that the
That was fine. That was a little slow even.